Hello and welcome to the program. I'm Millicent Walker. A senior advocate of Nigeria, Mr. Tunde Adejuigbe, is of the opinion that disobedience of court orders is tantamount to executive lawlessness. He believes the three arms of government are equal partners in running the government, and the Attorney General of the Federation ought to ensure that court orders are complied with.
What we have seen is the display of what the Supreme Court had described as executive lawlessness, in 1986 in the case of Governor of Lagos and Ojukwu, where they made this point that it is not in the best interest of the nation when the executive itself that should promote, the rule of law begins to flout and subvert the Constitution. The courts are not just there as mere decoration. They said the judiciary, the legislature, the executive, they are equal partners in running a government. So government has a responsibility to ensure, and more importantly, the Attorney General of the Federation ought to have ensured that the orders made by the court are complied with by DSS. And I think DSS is just trying to take everybody for a ride, which is unfortunate.
So where do you think the solution lies?
Well, it lies primarily with the executive to ensure that for the smooth running of government, don't forget that the executive initiated the process from day one. Showore was taken to court, he was arraigned, and in the same place you've taken him to, he applied for bail. So he didn't take himself to court, you took him to court. Now you want to decide which orders of that same court you will obey. And don't forget, this is also not the first time. It has happened with Dasuki's case. Several orders were made by the same court, by ECOWAS. And so when government does this, it sends the wrong signal of high level of lawlessness.
Another question is, what powers do they have? I mean, doesn't the power to execute rest with more of the executive? And talking about the judiciary now.
Just today, I was reading the papers and I read what Professor Shoyinka said, that thuggery and disobedience to court orders, they are the same. And that is what, we must avoid, and we must continue to make sure we draw me to the ears of those in government, that they are in office by virtue of the Constitution. The courts are also established by the Constitution. And when you begin, to denigrate what the courts are doing by sheer disobedience, at some point or the other, is going to become a rule of force.
Do you think this system also sort of influences other law enforcement agencies like the police?
Everyone. The truth is that no one is above the law. That's what we always say. And they say no matter how high you may be, how tall you may be, the law is still above you. So everyone, government agencies, organs of government, individuals, everyone is subject to the Constitution, and that's what the rule of law is all about. And part of the process is that even when the first court makes an order, you have your reservations about it, then there's still a process to at least go to a higher court and then the apex court eventually. But you cannot, whenever you want, decide to flout the order because of certain subjective considerations.
Is the court aiding and abetting the federal government, state governments to disobey court orders?
No judge in this country will aid or abet the government to disobey court orders. As a matter of fact, I think the judges will be disappointed when the government fails to obey their orders. Because why are they there in the first place? This issue is to ensure that the interest of the citizens and the government are balanced. And it's not, the courts are certainly not obeying and abetting the government.
So we have a judgment after a decade. Ojizu Kalu, former governor of Abia State, and this is 12 years imprisonment. It's taken this long. A lot of people have wondered why. Do you think this is a landmark judgment? What do you think make of the process?
Well, okay, let me start by saying this is one of the benefits of the Criminal Justice Act, bearing in mind that Justice Mohammed Idris is now a justice of the Court of Appeal. And if it had been under the previous dispensation before the coming into effect of AGJA, his elevation would obviously have truncated the trial, and it will have meant that they have to start de novo. So this is, at least for once, everybody could see that there is a major transformation in the system by virtue of the AGJA, and that is why it has been possible today to bring the matter to an end, at least in the court of first instance. And I think so it's a welcome development.
Why do you think there's a lot of delays?
Now, the position before now is that you have a lot of interlocutory appeals, which of course hindered the speedy conclusion of trials. And that is one of those things that the ACJA, dealt with in terms of getting them out of the way. But so if you go and check, it will mean not as if, though the case started long ago, but in between there have been interlocutory appeals, going as far back as Supreme Court, sending the matter back to the High Court. But now, ACJA eliminated stay of proceedings. So even if you have your appeal, while the appeal is being pursued, it will not delay the hearing of the matter. So I'm sure that some of those things that we had experienced in time past will no longer be a feature in the current dispensation of criminal justice.